To my left, we have Gönenç Gürkaynak, who's the founding partner of ELIG in Turkey.
We have very valuable speakers, so I'll try to be concise. It's important to put things into context. We have come to the conclusion that I should do a broader recap of where we are and give some context to the discussion that is going to happen. We had a couple of questions for you through Slido, but I don't know that we will do them because we need to move along. And there's quite a bit of ground to be covered. The very first question, obviously, that comes to mind is competition law fit anyway to address sustainability issues? I mean, clearly, sustainability is a very important public policy goal and preference, maybe the overarching one now that we're facing all the perils of lack of sustainability. But is competition law an effective legal discipline to target sustainability as a goal anyway? For those of you who know how to use Slido, which means for those of you who have been here before, feel free to please participate. The results we're interested in. It's definitely, maybe, not yet, not at all kind of a four responses question. My response to it is that competition law is indeed a good tool to address the sustainability issues. People that know me and have been following my approaches to competition law would know that I have a narrowing view of the prime objectives of competition law. So in that sense, I would not come up with an overexpansive view of what the prime objectives of competition law should be. It should be welfare maximization, targeting economic efficiency, but sustainability very naturally plays into this goal, and without sustainability, you cannot anymore have a meaningful midterm economic efficiency enhancing goal anyway. So from that perspective, I am posing the response that competition law has to necessarily integrate sustainability goals. Another question that comes very frequently to different fora is, do we see a concrete demand for a more lenient approach of the enforcers from the undertakings wanting to do good in terms of sustainability? In other words, is there demand for any sustainability leniency in the competition law realm anyway? Is this real? Even if we felt that theoretically sustainability is important in competition law, is it real that there is concrete demand by businesses? And a lot of people are saying there is no such demand. A lot of people are saying because sustainability is hip and cool, competition lawyers, especially the young ones, are subscribing into sustainability and competition law, and there's much a discussion about this theoretically. But when you come to the business world, really there isn't that kind of a demand. I would propose that that's not correct either. We're throwing at you two very recent cases. One is of June 27th, 2022. The other is of July 2022. And we're not talking about the chicken of tomorrow anymore, which is a case that has been beaten to death in basically the sustainability realm. Everyone talks about it. The Dutch authority has been progressive afterwards, and we have learned lessons since 2015. Yes. But since then, we haven't been talking about concrete cases. Well, one is Shell and Total Energies, and the Dutch authority this time says to these two companies wanting to engage in pipeline transport of CO2, but thinking that that pipeline transport of greenhouse gas is going to lead to competition law issues. The ACM, the Dutch authority, openly says the slight restriction of competition between Shell and Total Energies is not that harmful. That harmful is not a technical thing to say. It means we understand what sustainability is. We are living on a flat land that is right near to the sea. This CO2 is in the North Sea. Thank you very much. And that is actually, that has to do something with more than the realpolitik of competition law. It is actually the welfare function being built directly into competition law enforcement. The second case, or matter, I should say, because it hasn't turned quite into a case, there has been a very new development in November 4th that I will tell you about, but it's still not is a case, is the Net Zero Insurance Alliance matter. In the G20 in Venice, the last one, in July, 8 insurance companies have pledged that they will not support any new coal ventures anymore, and they will phase out coal-generated power. And then others have jumped into the bandwagon. So now this is a band of 29. And they came up with a statement of commitment. This is a UN-convened group. And the Net Zero Insurance Alliance was formed. In the statement of commitment, they actually are subscribing to what we would call, if we're teaching this to the students, a collective boycott. Yet, as the ICC Task Force on Sustainability and Competition declared in their white paper of November 2022, then started the fear in 2 directions. One, the Race to Zero of the UN has amended its interpretation guide. And they said, we're not anymore requiring member organizations to explicitly stop working on new coal projects. That was the case before. They said, maybe this was too much. We're fearful of competition law matters. This is the reading of the ICC task force through their white paper of November 2022. And the Glasgow Financial Alliance for Net Zero, which is the heart and soul of this alliance, actually, said they're dropping the requirement that its members sign up to UN Race to Zero initiative. The ICC also reads this as them being scared of competition law enforcement probabilities. And in November 4th, and these are my last sentences so that I'm not using too much time, in November 4th, just within the last 2 weeks, according to the Climate Law blog, the Republican attorney generals in the US, 19 of them, have announced that they're launching an investigation into 6 of the Net Zero Banking Alliance signatories. And they're bringing a case in the US against these banks for concerted efforts to block fossil fuel companies from receiving financial services. So going back to the question of whether sustainability goals need competition law help and whether the intersection between these 2 policies is something to be worked on, I believe the answer would be yes.